Hello everyone, welcome back to my channel Study with Neha Mawa, and I'm back with another video on the topic that is the Contempt of Court Act 1971. So in today's video we have to start from section number 13 till 24. So we will be completing the whole act in today's video, and we are going a step further in that. So before I will start this video, I would like you to subscribe to my channel, like my video if you find it interesting, and share with your friends. Let's get started. So in today's video, I am going to start with section number 13. So in the previous two videos, I have completed from section 1 till section 12. So today I will be starting section number 13, that is contempt not punishable in certain cases. As I have told you earlier also, that contempt of court should not be taken very lightly. It should be taken very seriously because the after consequences may be very dangerous for the person who is punishable for contempt. So here they are saying that the contempt not punishable. Sometimes in certain cases contempt is not punishable at all, but in some cases the contempt is punishable depending upon the case to case. So here I am talking about, so here we are saying that notwithstanding anything contained in any law for time being in force, no court shall impose a sentence under this act for contempt of court unless it is satisfied that the contempt is of such a nature that it substantially interferes or tend substantially to interfere with due course of justice. Right? So, main the Contempt of Court Act 1971 is strictly made for those who tries to interfere in the administration of justice. But if a person who has doesn't intervened, or who has not shown any kind of interference in the administration of justice or in the workings of the court, you can't make that person to be held and to punish that person for the contempt of court. So the first 30, the clause A of section 13 talks about this procedure. B says that the court may permit in any proceeding for contempt of court justification by truth as a valid defense if it is satisfied that it is in the public interest and the request for invoking a said defense is bona fide. As I said you in earlier videos also, for example, if I am publishing any kind of information that is true to its knowledge, that has not been altered by me, so I would not be punished. Okay, I will not get punished for the contempt of court. Okay, then we have section number 14 that talks about procedure where contempt is in the face of Supreme Court or High Court. High Court and Supreme Court has the power to punish the person for the contempt, right? So when it is alleged or appears to Supreme Court or High Court upon its own view that person has been guilty of contempt committed in its presence or hearing, the court may cause such person to be detained in custody at any time before the rising of the court on same day as soon as possible, right? The person will be behind the bars. Cause him to be informed in writing of contempt with which he is charged. For example, I am arresting this particular person and I am making the person liable for contempt. So firstly, let me give him or her the cause, the reason in writing, that what is the reason he is charged, which for how means for what he is punished, for what he is charged under the Contempt of Court Act 1971. That should be properly, conveyed. Second is afford him an opportunity to make his defense to the charge. We will give the person a reasonable opportunity to speak, to give his defense, and to speak in his own favor. Third is, after taking such evidence as may be necessary or as may be offered by such person, and after hearing him, proceed either forthwith or for adjournment, right? When both the things are satisfied, then third thing should be done, that should be take the decision, should be taken the decision whether to adjourn or whether to make that person liable. And the last one is make such order for the punishment or discharge of such person as the case may be. Second is notwithstanding anything contained in subsection 1, this part, where a person charged with contempt under the subsection applies, whether orally or in writing, to have the charge against him tried by some judge other than judge whose presence or hearing the offence is alleged to have been committed, the court is of opinion that it is practicable to do so, and that in the interest of proper administration of justice, the application should be followed. It shall cause the matter to be placed together with statement of the fact. Means proper procedure should be laid down. If you are making a person liable for the contempt of court, then you should follow a proper procedure. You should follow a good or the way it is to be, you know. Then we have subsection 3, notwithstanding anything contained in this, it talks about the same as we have started in subsection 2. Fourth is pending the determination of the charge, the court may direct that a person charged with contempt under this section shall be detained in custody as it may specify, provided that he shall be released on bail if bond for such sum of money as the court thinks sufficient is executed with. Either the bond is signed by him, by the person, or either the sureties will be given. So that person charged shall attend at the time place mentioned, right? The bail, a person is given bail on one condition, that person has to obey the orders of the court, and the person has to present in the court whenever called upon by the magistrate or by the court. Then we have section 15 that talks about cognizance of criminal contempt in other cases. As you know, we have two contempt here, civil contempt and criminal contempt. Here they are talking about the criminal contempt. In that case of a criminal contempt, other than the contempt refers to in subsection in section 14 of Supreme Court or High Court. Now, who may take the action? The Advocate General or the other person with the consent in writing of the Advocate General. In relation to High Court, for the UT of Delhi, law officer of central government as notified in the official gazette, right? In the case of any contempt of subordinate court, then High Court may take an action, reference made to by the subordinate court on a motion made by Advocate General of the UT, right? Every motion or reference made there made under this section shall specify the contempt of which the person is charged to be guilty. In this section, Advocate General means in relation to Supreme Court, Solicitor General, and in relation to High Court, the Advocate General established or with recommendation of the central government. Then in relation to Court of Judicial Magistrate, as law officer as the central government may notify in the official gazette. Then we have section 16 that talks about contempt by judge, magistrate or other person acting judicially. Now, contempt is not always done by the normal person or the ordinary person, but sometimes the contempt is done by the judge himself, by the magistrate, or by the other person, those who are acting judicially. Now, subject to the provisions of any law for time being in force, a judge, magistrate, or other person acting judicially shall be liable for contempt of his own court or for any court in the same manner as the normal individual or a simple individual is liable under the provision. So we can't give we can't give the special defenses to judges, magistrate, or other person acting judicially, because everyone is equal in the eyes of law. So we have nothing in this section shall apply to any observations or remarks made by a judge, magistrate, or other person acting judicially regarding a subordinate court in an appeal or revision pending before the judge or magistrate or person as the case may be. So here section 16 talks about whether it is a judge, whether it is a high official, law commissioner, whatsoever it is, the person can't get the defense. The person has to be liable. The person has to person has to get the punishment for the contempt, irrespective whether the person is judge, magistrate, or the ordinary person. Then we have section 17 that talks about procedure after cognizance. Notice of every proceeding under section 15 shall be served personally on the person charged, unless the court for reasons to be recorded direct otherwise. Notice shall be accompanied in the case of proceedings commenced on a motion by a copy of the motion of all. They have given you the procedure, right? How you can do that. So you have to go through it. Then we have section number 18, that hearing of cases of criminal contempt to be by the benches. Every case of criminal contempt under section 15 shall be heard by the bench, which should consist of the two judges, not more than two judges. Then we have appeal. Can we do appeal against that? So an appeal shall lie as of right from any order of decision of High Court in exercise of its jurisdiction, right, where the order or decision is that of a single judge, to a bench of not less than two judges. You can do appeal, you can go for appeal if the judgment is given by the single judge, right? You can go for appeal where the order of the decision is that of a bench to Supreme Court, provided that where the order or decision is that the court or the judicial commissioner in any UT, such appeal shall lie to Supreme Court. So pending may appeal, the appellant court may order that the execution of the punishment or order appealed against be suspended. If the appellant is in confinement, be released on bail, and where the appeal be heard notwithstanding that appellant has not purged his contempt, right? Now, the appeal under subsection 1 shall be filed if it is in front of the High Court within 30 days, if it is Supreme Court 60 days. Then we have section 20, limitation for actions for the contempt. No court shall initiate any proceeding for contempt outside its own jurisdiction, or either on its own motion or otherwise, after the expiry of period of 1 year from the date on which the contempt is alleged to have been committed. Means there's a time limit for taking the actions of contempt, right? There is only minimum time of 1 year under which you can file for contempt, and you get the benefit of out of that, otherwise you can't get. 21 says that act not to apply to Nyaya Panchayat or other village court. Nothing contained in this act shall apply in relation to contempt of Nyaya Panchayat or other village court by whatever name known for administration of justice. If someone is interrupting or interfering in Nyaya Panchayat or other village court, they can't be, this act does not apply there. Then we have section 22, act to be in addition to, not in derogation of, right? So provision of this act shall be in addition, means the provision shall make this act more better, not to derogate its reputation, not to derogate the administration of justice. Then we have section 23, that is power of Supreme Court and High Court to make rule. Supreme Court, as the case may be, High Court may make rule not inconsistent with the provision of act. Whatever they are making, whatever rules they are making, that should be with the conformity of the laws. That should not affect negatively to any person, to any institution, to any system of the country. And we have section 24, that is repealed. So this was all in today's video, and with this video we have completed our the Contempt of Court Act 1971. It is not that big act to be read and to be followed. It's a very small act. You can go through it in 1 hour or in 2 hours. You can study whole the act very simply and with full understanding, right? So this is for all, and that's it for today. Do follow me, do subscribe to my channel, and like my video. Thank you. Have a good day.